Okay, so hi everyone, and thanks for being here, both online and here in the room. Just I'll have a quick welcoming word just to let you know where we are. We are at the EDRi offices, which stands for European Digital Rights. We are the network of digital rights organizations here in Europe, and we represent more than 60 NGOs working on digital rights. From Brussels, which is where we are currently. We do mostly policy work, trying to work with EU policymakers in countering anything digital rights related. And in particular, we've had a long history of cooperating with MEPs such as Sophie in 't Veld, who's also in the room with us regarding the spyware topic. And that is why we are here co-hosting this presentation of a paper on the Pall Mall process. So I'll just have maybe a quick word on what is EDRi's position on this topic, and then I'll hand over to you. So I just want to say that from the civil society perspective, what we have seen from the beginning is that this was a process that was driven, we are sure, with very good intentions, and it is very welcoming that there is at least something happening in this aspect, because it's not common to see. At the same time, from the beginning, we had some doubts regarding the voluntary nature of the whole discussion. That was something that was kind of bothering us from the beginning, in the sense that we don't know how applicable any outcome could be, especially when we are talking about an industry that has very strong and very potentially harmful players behind. And also there is one part that clashes a bit with our position, which is that we are advocating for a full ban on spyware as the human rights compliant perspective. And in this case, this process does kind of appear to legitimize certain spyware use cases, which is a bit conflicting with our joint position, let's say. Also, there is one thing about the process, which was the civil society engagement in it, because this was this is a multi-stakeholder, multilateral process. But when it comes to the engagement of civil society, we have acknowledged certain shortcomings at certain stages. It hasn't been as open, as transparent with civil society as we had wished. First, because of the type of engagement that we've had, but secondly, also because now that is the turn for industry to also take part on this process, we don't know exactly which actors of the industry are doing what, and that is something that, as you might imagine, deeply kind of concerns us. And then, well, wanted to say again that now it is true that this is the only thing that we have currently as an initiative to regulate or to put some order in the spyware space. At the same time, this has had a kind of a backlash effect that might not be foreseeable at the beginning, which is that now many states that are involved in the process, especially EU states, which are the ones that we work with, are using this process being there as kind of an excuse or as a way of saying that is why we are not doing anything on spyware, because we are already engaged in this process. Whereas, we know that the EU has strong power competencies and could be exercising those, which could be parallel and complementary to the Pall Mall process. But they've tried to use or instrumentalize this thing to do this, to hide behind it, to justify their inaction. So that is all from my side. We are also a bit concerned or looking forward to the new code of practice for companies, especially on the effects that this could have in legalizing or establishing a blueprint for certain companies to appear as legit actors and legitimate, which is not something that we would like to see, especially with the human rights violation records of some. So that is more or less our general position, and now I'll give it to Professor Ní Aoláin, who would very kindly present this amazing paper.
Thank you. I really want to start by welcoming those who've joined us online, and I particularly want to thank EDRi for hosting this launch. We thought it was really important to launch this document in Brussels, because actually the report, which is available online, and for those of you who would like an actual hard copy, we actually have old-fashioned printed hard copies as well, so please reach out to us and we can send you one. But we thought it was really important to launch this in Brussels because actually this is also really speaking to EU member states, and the report itself makes clear that actually we see particular obligations, including hard law obligations for EU member states in this space. And I was very interested in mapping the relationship between the soft law process and sort of hard EU law obligations, of which I'll say more. So particularly thanks to EDRi. Second, thanks to Sophie for joining us, who's, I want to say, somewhat of a hero of mine. So I'm really glad that she's here to launch this report. It feels particularly important to have her voice in the room, and also just acknowledging the extraordinary work that she has done to bring legal attention and political attention to what I think we both agree is an existential threat to our political and legal systems. And so the work is important. Thirdly, I want to thank the Human Rights Centre, which is my home institution, and Abby Nelson, who's joined me here today from the US. I have had a lot of support to help make this report happen. And two other thank yous before we start in, which is the Spyware Accountability Initiative and the community of practitioners, many of whom are listed in the acknowledgement, who are too many to list, who have given feedback and advice and counsel, and who might see this report as very much a report of partnership with the broader spyware human rights community, which I think is a really important ecosystem and a highly supportive ecosystem working in really difficult circumstances. So it might be helpful. I'm going to take maybe 15 minutes or so where I'm going to actually talk through the report for those online who haven't had a chance to read it yet. And I know we're joined by some journalists. I also want to acknowledge that we're joined by some folks from the Pall Mall team. And I do want to say we've had both as UN Special Rapporteur, when I started this work on spyware, have had a really constructive and positive relationship with the UK government on this issue. We don't always see eye to eye on certain matters, but we also have had just a very constructive conversation. And like Roche said, we want to recognize that France and the UK are two countries who, at least in this context, are really recognizing a challenge and seeking to address it. This report in many ways gives advice to those governments. So the audience is both civil society, but it's also governments in terms of thinking how we could work in this space. So maybe just by way of background to say, I came to this work when I was UN Special Rapporteur on counterterrorism and human rights. And I would say with great honesty that I was not a tech person before I became, I had my chief tech advisor was my teenager. But I suddenly recognized when I came into mandate in 2017 as someone who'd historically worked on issues of security, that actually technology was central to what was happening in security space. And in fact, counterterrorism and security arguments were being consistently used to justify the early adoption, fast adoption, non-regulatory adoption of new technologies. And actually, that's where spyware first came into my zone of recognition. And as Special Rapporteur, I was both seeing the leverage of these security arguments, but also seeing a move that I really address in this paper, which is that security space and counterterrorism space in particular is increasingly post 9/11 dominated by soft law regulation. So that's an oxymoron for the international lawyers on joining in. We think of law as hard. If we talk about law, we assume it's something that's binding. But of course, international law has this category of things that we call soft law. And for many, the oxymoron of soft law, and I think the thing that has been happening in security and technology and security practice for the last 2 decades, is that soft is in fact hard. States are choosing to seek non-binding measures, but in many ways, those binding measures are both replacing traditional hard law, meaning that states are not seeking to use hard law methods to address striking social and legal problems, but also that the soft law effectively becomes hard, that the nomenclature is deceptive because the states treat this in practice. In 2023, I issued a scoping paper, which this report builds on as UN Special Rapporteur, where I addressed both the harms of spyware that I'm going to talk about in a minute, but also where I really focused on this question of if we were to regulate. And I say if because, as this paper makes clear, it is not, I stand by the proposition that as currently used, spyware is simply incompatible with states' fundamental human rights law obligations, meaning it is indiscriminate structurally. And the result of that is that its encroachment on both derogable and non-derogable rights means that it is in fact incapable in its current form of being regulated by states who use it in a way that is human rights compatible. So to respond to that challenge I saw and responding to wider use, as this report identifies, there's up to 100 states that we believe have access and use of spyware. That's a lot of states. That crosses, as we know, in the European context, both democratic and non-democratic states. But I developed a model of what I called regulation by design. That if, and that's the big, I want to underscore the word, if spyware was to be regulated, it could only be regulated if it had certain design features that were required in advance, that would enable us to limit its de facto disproportionality and in use. And that would include things like a requirement, a kill switch, that you could just switch it off. It would include things like indelible records. It would include these like structural requirements that if you were going to use this tool, you actually had to change the tool itself for it, in fact, to literally be capable of regulation within a framework of proportional, necessary, non-discriminate. The harms of spyware, the people I think on this call, but I also want to say particularly EDRi, Sophie and others know the harms of spyware all too well. One of the things I stress in this paper and have broadly stressed is that there's a tendency, it's really important, of course, to focus on spyware as a privacy violation harm, like that's the place where we naturally go to, and I certainly endorse that. But I want to stress that actually spyware engages both derogable and non-derogable rights. The fact of the invasion of privacy, which is inherent in use, is an invasion that then triggers these other, like, absolutely profound violations. Violations of the right to life, Jamal Khashoggi, violations of torture, arbitrary detention, enforced disappearance. Spyware is the lever. The privacy invasion is the lever that triggers these other things. So I often think it's a mistake both for states and for civil society to simply focus on the privacy violation, because we live in a world where privacy is viewed as a less sort of important right. And in other work, but not in this position paper, I have argued that the time is ripe for a recalibration of privacy in the hierarchy of human rights norms, meaning that when we created the post-World War II legal framework, privacy was a right that could be limited or derogated from, because the capacity of the state to intrude on the private life of the person was in fact limited. But spyware points out to us that in fact the challenge is that there's no limits on the state's encroachment of privacy, and this space between the individual and the state disappears. If there's actually there's no line that exists anymore with spyware and similar intrusion CCICs, these tools that essentially are these cyber intrusion capacities that simply are so functionally indiscriminate that there's no line. And that speaks to the need to rethink privacy, to say actually in the digital age, as the High Commissioner for Human Rights has argued elsewhere, privacy is an uber norm. It's a grund norm. It's a norm from which both civic space follows, but actually political systems in our digital age can only function if we respect a right to privacy in a fundamental way. This brings me back to the framework that has emerged around Pall Mall. And one of the things to know is that the Pall Mall process emerges out of essentially a failure of states to regulate by way of hard law. And we know, and I think in the European context, we're deeply aware that there are several tools that states have available to them. Export controls, for example, is a huge area of potential capacity. And we've had, I think, very important interventions by scholars, by practitioners on how we might actually augment our export control systems. I think of the work of Mark Bromley, Zach Campbell at Human Rights Watch and others recently that really do that. And we also have sanctions tools, and we've seen the US government, for example, make good use of both sanctioning individuals and related family members in the spyware space in terms of, but these tools are effectively underutilized. And I think as the history of the process is laid out from page 3 or 4 of the report, lays out the sort of creation of the Pall Mall process was both because of the failure to regulate in hard ways, but again, I think this broader trend that we're seeing of states using soft rather than hard, and following what is a pattern in sort of national security, counterterrorism space, or arguments from security. And there are many things to say, but one thing to say is, of course, as we've already heard, in some ways, Pall Mall is the only game in town in terms of a framework of talking with a large group of states about how one might, quote, regulate the market in spyware. But to be clear, Pall Mall is not a regulatory framework in the formal sense. It's a process. And there are a number of features of this process that I just want to point out. So I think many, and I think in the room would know that, and I would go back to the PEGA report on this, that when states were identified, I would say several years ago, as having been users or transferers of spyware, I always think of it as a kind of embarrassed silence where nobody wanted to acknowledge that they had done it, right? There was a kind of a denialism culture about the use of spyware, especially for democratic states, but even for non-democratic states, there was kind of an ick factor around spyware, particularly because of the companies who were associated with its use and propagation. One of the things that concerns me is that Pall Mall moves us from a denialism of use to an embrace of use. And in fact, in many ways, we can see it as a framework that normalizes use, that encourages use, that recognizes, and even some of the languages anticipates further use. Now, of course, the framework, and it's interesting, of course, we'll all know that the Pall Mall process defines CCICs as tools and services made available by cyber intrusion companies and similar high-end capabilities developed by other companies. So it's a broader framework than spyware. But I think one of the things that framework does is that by kind of putting spyware into this category of one among many tools that are used by states in the cyber surveillance space, it sort of minimizes and deflects from the specificity of harm and the scope of challenge posed by spyware. So it's true, all of these other tools are deeply concerning. We have low-end tools that do an enormous amount of harm to civil society, to the integrity of legal process, to the integrity of diplomatic process. Part of what has triggered, for example, the US role of regulation in the space, at least under the Biden regime, was actually the understanding that their diplomats were the targets of this kind of surveillance technology. But as sort of a starting matter, what the Pall Mall process does is essentially recognize, affirm, and potentially expand the legitimacy of a market in these broad set of tools, and by not elevating and specifically highlighting the dangers and the need for higher and more specific and pointed regulation of spyware as a specific tool, I think it minimizes both the harm of spyware and suggests to states that actually there's a kind of a lower threshold of regulation that's appropriate. And I think that is, quite dangerous. So that normalization and legitimation process. The second challenge I think we've seen, and as noted, this is a tripartite structure. And actually, I have a lot of time for tripartite structures. I worked with them as special rapporteur. Financial Action Task Force is a really good example. We've got tripartite structures in the ILO. We've seen tripartite structures in UNESCO. Tripartite structures can be really good things. They can bring stakeholders together. But in order for them to be really good things, they actually have to elevate and sustain the capacity of all the stakeholders to have an equal and meaningful say in the process. And I think, as the report notes, there are really profound questions about the inclusion, participation, and influence of civil society. And I include myself in that. And I've had the privilege, both because I've been a special rapporteur and because I practice as a KC, I get access to some of these conversations. But my access isn't determinative of who in general has access and who are the most affected by spyware, who have meaningful and holistic opportunities to engage in the process. One of the challenges of a soft process, I think, is not just that civil society is at a structural disadvantage, but that also we're very unclear about what the participation of these business entities is in this process. What's the actual basis of their participation, and what's the relativities of participation and the influence of one group over the other? So the process, if it's to be a process that meaningfully includes civil society, has to be far more transparent. The other aspect of this process piece that I really want to sort of focus on is the ways in which human rights gets marginalized in soft law processes. And I have seen that over and over again in UN spaces, but also in multilateral spaces. So what happens is, generally speaking, the people who are making the arguments for human rights are civil society, the ones with the least power and the least capacity and the least resources to engage in the process. The nature of Pall Mall, I think, is that the experts who are sitting around the table are cyber experts for the most part, sometimes experts in crime and other sort of internal security matters. But the challenge is that we often don't have human rights experts at the table when any of this is being negotiated, including the proposed code of conduct for industry. And the problem with that is the actors with the least voice, the least capacity, are the ones making the human rights arguments. And in human rights spaces, right, if we were in a formal treaty space, the Office of the High Commission for Human Rights, a UN Special Rapporteur, commissioners and other kinds of human rights actors get to be at the table and engage with states about the sort of competencies and core language that's in the treaty. But that doesn't happen in these soft processes. It's not built in. The argument is always external. And I think that speaks to another test. And one of the things I have done, I'm a very kind of boring black letter lawyer. So one of the things that in this report is I've taken the code of practice. If you look at the back of the document, what you'll see is I've reproduced the Pall Mall code, and then I've done a legal analysis, like boring black letter law legal analysis. But what that shows you, why that analysis is, I think, important and useful for civil society, is that it shows us the difference between the specificity of language we find on the issues, the quote, technical cyber issues, and the kind of generic, I call it the decorative edge on the rim of the table approach to human rights. We just sprinkle the word human rights here and there. But actually what we're not doing is specifying exactly which human rights and exactly how these human rights are being violated, which in turn signal to states what their actual human rights obligations are under their existing treaty law. So those are some of the general things I would say. I want to say that in the detailed assessment of the code of practice, this march towards normalization is one of, I think, the key things we take away. The legitimization of a state market in this tool is one of the things that we take away. The third is we also, in addition to, I think, it's not that human rights language isn't there. And I want to commend both France and the UK for including the human rights language that is there. It is important. But I also want to point out we've imported a new set of terms into the Pall Mall Code of Practice. We've got words like precision and transparency. Now, no one's going to argue about transparency, but actually in human rights treaty terms, that's not a word we use. We don't have a set of benchmarks or interpretations of state obligations on that. On precision, this is language that's taken from other areas of international law practice, not human rights practice. And so what it tends to do, what we're seeing, I think, here is a sleight of hand, where these words that kind of sound like human rights words get pulled in, but they're words without a lived and clear meaning and state obligation in this area. And I think that's really dangerous, because I think the consequence of that is it fails to articulate with specificity, given the dangers we know about this tool, what the obligations of states are. So let me close by saying two other things. At the bottom, at the end of this report, we find one of the things that we know. I make a number of recommendations that if the Pall Mall code is a code of practice for states is an iterative process, then I think the concerns of civil society and experts like myself in terms of strengthening that should be taken on board. If we're genuinely talking about an iterative process that can amend itself, then it would be, I think, really incumbent on the states leading this process to think about how to do that better. But of course, we're now in another phase of Pall Mall, and the next phase of Pall Mall is the establishment or proposal for a code for business enterprises. And just let me say a couple of things about that, because the report deals with this at some length. One is, again, I'm just going to reiterate everything I've said about having soft law to regulate business enterprises, many of whom have been found guilty of systemic violations of human rights in the use of this technology. So I'll take note of the NSO WhatsApp litigation, but also just to say I issued a global report on the impact of counterterrorism measures, including surveillance on civil society and civic space 2 years ago. And in that report, we documented across the globe, as multiple NGOs have been doing, again, EDRi, Access Now, CBT, others, there are Citizen Lab, Amnesty Lab, so many organizations who are documenting day in and day out, as many brave journalists who are consistently elevating for us the misuse of this technology and its impact on real people. But also on people who are engaged in the business of protecting democracy and the rule of law in multiple states. So the code for business enterprises is deeply worrying because, again, it speaks to a move of legitimizing and potentially a process for rehabilitation of certain companies, of tech washing, what will be essentially companies who we have found and evidence to be systematically engaged in serious human rights violations. The second thing that worries me is if we look at companies like NSO Group, they've been asking for soft law regulation forever. So one of the really big dangers here is we're actually giving the companies the thing they want, which is they want this. They want some version of this because this they think they can manage. What they don't want is hard law regulation. And I think it's a very dangerous signal to send that companies are getting this and they're not getting hard law regulation. And what I tried to do in this report is set out both the binding international law that binds states and business enterprises, that includes both hard and soft law, but also I set out in this report what I call the red lines on a code of conduct. And those red lines I see as absolute red lines that if we're going to go down, and I think there's reasons why states shouldn't go down this line of creating a code of conduct for businesses in this area, that there are actually a host of things that are simply unacceptable. And let me just maybe highlight a couple of those. If you're following the report, it's on page 29. The red lines are on page 29 through 32. They include a code must define the specific technologies and activities that are covered. A code has to promote and underline that business enterprises are bound by existing laws and obligations. A code cannot frustrate existing treaty obligations of states in respect of business enterprises. A code has to precisely define the commercial cyber intrusion market, what it includes and what it does not. And I think another really important thing, and the danger of this code, is that it sort of blurs over the distinction between business enterprises whose platforms and products are being used, leveraged, and undermined, and whose commitment actually to the prevention of human rights violations through their platform is being increasingly proven, like WhatsApp and others. And those business enterprises that are in fact exploiting and manipulating and abusing those platforms. So by failing to make a distinction between actually business actors in this space who are trying to advance human rights work and those who are not, I think we make a serious mistake. So let me close by saying that I think that spyware constitutes an existential threat in so many ways to democracy, to the rule of law, to human rights. It's as it stands, it is a disproportionate tool that is being used in ways that are completely unregulated by many states. And to remind people, going back to 2005, when we were, this is a long time ago, but there was a debate in the early 2000s about whether we would or we wouldn't regulate drones. If people recall that debate. We had a new technology, small numbers of states had it. And those states who had it didn't want to regulate it because they thought, we get to use this. Look where we are now. We have a war in Ukraine being fought by a technology that's not regulated at all. We have a war in the Middle East that the use of drones is in fact changing the nature of the understandings of the parties' capacity to engage in conflict. And we missed the opportunity to regulate because we had so much hubris about the sense that it could be controlled in a way that wouldn't involve widespread proliferation. And it seems to me that if states are really interested in security, they would be thinking about the nanosecond we are away from having spyware transferred to third parties, including non-state armed groups. I think we are so close to that, and we have zero regulation, and that speaks to the need for hard regulation in this area. So over to Sophie. And you want to swap?
Yeah.
So we can see you, Sophie.
Yeah, before we pass it to Sophie Intveld, who will also share some reflections, just to remind that after her intervention, we'll have a Q&A session. So if you want to share either questions about the report, or even share your reflections, and particularly also speaking to the people engaged in the Pall Mall teams, we also welcome your reflections on how do you feel about what's been said, and yeah, we'll open that in about 5 minutes.
Perfect.
And Sophie, please.
Hello, everybody. Well, first of all, I would like to thank you for the opportunity to read and comment your work, because I'm very, very impressed, and even more by the introduction that you just gave, because you touched upon all the important issues. And but I'm going to be even a bit more radical, I would say, about the Pall Mall process. I think, it's not only a question of whether or not it will achieve results. I actually think it is dangerous. It's a distraction. It is taking up massive capacity of researchers, NGOs, whereas we all know the Pall Mall process is not, its purpose is not to restrict and regulate the use of spyware. Its purpose is to legitimize, as you've also said. And then if we look at the people leading, or the countries or the governments leading this process, I mean, the first question we have to ask ourselves is, how sincere are they? How reliable are they? How committed are they? And don't judge them by their words, judge them by their actions. And then I see that, many of those governments are, as we speak today, abusing spyware and exporting it to undemocratic countries, knowing that spyware will be used for the violation of human rights. So why do we put, let's say, the fate of democracy into the hands of the people who have absolutely no intention of respecting the rules? And those were in particular EU governments or EU member states. They could have embraced hard law. They rejected it. They didn't even want to discuss it. What's worse, the hard law that exists is being violated, trampled on. We have the European Commission just say, like, literally, I'll never forget, Commissioner Dombrovskis, who in the previous period was responsible for exports policy, throwing his hands in the air, saying, "Oh, I have no powers to enforce the export rules." So I thought, okay, then we might as well abolish, the whole commission. I mean, why do we pay you 25,000 euros a month if there's nothing you can do? Why do we even have these laws if they're not being implemented? And then, I mean, as to the companies are just, they only want to make money. If they could become rich by promoting human rights, they would be promoting human rights. But they will be rich by destroying human rights. And even what's the use of having a code of conduct when they have self-imposed rules? There are, in their contracts, there's due diligence and rules for the users. They need to get licenses in order to export the stuff. And then somebody needs to explain to me, if they're really respecting those rules, then how come the stuff is all over the world being used to violate rules of all sorts? Come on, this is just not serious. So we all spend endless time and energy and means on trying to be involved or to study the process, whereas this is all, it's a big distraction. It's a smoke screen, and the real action is taking place somewhere else. So I do think, and it's an uphill battle, because there will not be hard law anytime soon. Yeah. And I think the only weapons that we have is litigation, raising public awareness, because the thing is, the people who are in government, having political power, and the industry have zero interest in regulating. Zero. Even governments who are not currently or abusing the stuff or exporting it, they are enablers. Like the Irish government, maybe they're not exporting it, maybe they're not using it against journalists, but they're rolling out the red carpet for Intellexa, giving them, a favorable tax treatment. So they're all enablers. And I have highlighted many times during the inquiry work in the European Parliament that all the governments had agreed, they have discussed it and agreed and declared publicly to the European Parliament they refuse to cooperate with the inquiry. So that makes them all complicit, every single one of them. There isn't one that's better. It's not because, I don't know, Sweden hasn't been using it that they're not guilty. Yes, they're guilty. And so there is zero will on their side to tackle this problem. Human rights, they've all signed up to all the treaties, but they don't care. This is the hard reality. I'm not even a cynic. Imagine I were a cynic. So then the thing is also that I think there is and I've highlighted this many times, there is a risk in framing this as a human rights issue. It is a human rights issue. And if you have been the target of spyware, then that's dreadful. That's devastating for the persons who've been victim. But the point is, the bigger threat is to democracy, because the people who've been targeted are not just random citizens. They have been targeted because they are, let's say, the watchdogs of democracy. They are the people exercising public scrutiny. They are opposition politicians. They are, I don't know, lawyers or NGOs or academics exposing corruption. Because this you have to understand. All the waffle about national security, I mean, this is being used very little for, well, I'm sure it's being used for national security as well, but it's mainly, the abuse is always about strengthening power, autocracy, authoritarianism, and covering up for corruption, for nothing else. So it's always the people who are in the way of power and corruption who are going to be the target of this. So what they're using spyware for is eliminate checks and balances, and I happen to believe that is the very core of democracy. It is not elections. I always point out there are elections in Russia. It's not a democracy. There are even elections in China. The core of democracy is that there's no absolute power. Power is by definition limited. So if you then remove the limits to power, and this is also why there's something funny in us saying, well, it can also be used by democratic governments. But the very moment they use spyware to eliminate checks and balances, they're not democratic governments anymore. And this is happening today. I mean, Italy, for example, is one of the countries also leading the process. The Italian government is using spyware against journalists, against NGOs, but even against business people now, because they're using it for because there's a controversy over banking mergers and stuff like that. So they're on the one hand, so they're talking nice talk about the Pall Mall process, and at the same time they're abusing the stuff. So how serious France? I'm sorry to say, France. If France were really concerned, really seriously concerned, why don't they open up about the illicit exports that have taken place? They're still in court for illegitimate exports of spyware so many years ago to Egypt, I believe, and to Libya. And so why don't they stop that? They've been issuing licenses, or they've been turning a blind eye to. So I don't believe that this process is going anywhere. So I think we need litigation, and it's very, very difficult, very, very difficult, but there are still some cases pending. So we have to do everything we can. All our means, all our capacity should be going to supporting those cases, awareness raising, and then hopefully maybe there will also be some solutions, some technical solutions in terms of people being able to protect themselves. And I know that there are some there are some technical solutions, but they're not very convenient. They may not be available for everybody. I mean, what we would need is something like a very cheap app you can download on your phone that's going to protect you from all this rubbish. So if there were, because I'm a total nitwit, I don't even have teenage kids, so I'm sort of on my own lost. But if there are companies or developers who really, really want to do something about this problem, then they should be developing like a protection for your device, and it should be very, very accessible. It should be cheap, easy to use, and because I think, and that's the last thing I'll say, because you made the comparison with drones, I actually think spyware is more dangerous to our society than drones.
Yes,
because it's not just drones may be used to for physical attacks. This is just completely unraveling democracy. Completely, it's handing power to a few individuals, and it takes us right back to the Middle Ages or before.
Yeah.